Hi everyone, this is Ral Obioha from the Law Office of Ral Obioha, and I'm an immigration attorney based in Houston, Texas. And today I just wanted to talk to you guys about the new public charge rule. It's a rule that was finalized by Department of Homeland Security. I believe that was mid-August, and this rule is set to become effective as of October 15th. So all applications filed before October 15th will not be affected, but you might want to get a head start on filing those applications. Now this video would be just kind of like a summary to go over what it means and what it might mean for you and your case, and kind of like what the DHS is now looking at. Previously, when filing applications for a family member and you're looking to adjust your status based on an approved immigrant petition or based on marriage or, parent or child, the minimum requirement was that based on the Form I-64P that your sponsor meet the 125% of the household poverty guidelines, which has been established. But then here's the thing, you could always get a joint sponsor to a friend, a family member, anybody to basically that and is willing to submit their tax returns and sign the affidavit of support, swearing that they would be in charge of the immigrant and that they would make sure that the immigrant is not a public charge. Now, what people don't know is that before this, in the INA, which is, the immigration law code, so to speak, there's never been a definition of the public charge. There's been this vague kind of concept, and it was easy to get by if you could get a joint sponsor to prove that they to sign that they would take care of you as an immigrant if your petitioning sponsor is not able to do so. It doesn't meet the guidelines. Now with this new public charge rule that is that is going to be implemented October 15th. Now I waited this long to give this video because there are a lot of lawsuits right now trying to stop this rule from going into place. But we're about a month out and nothing is sticking, so we just don't know if people are able to enjoy this. Then it may not be effective. But as of now, it's set to become effective as of October 15th. Now, what a public charge is somebody who is likely to depend on U.S. public resources to meet their needs. The U.S. does not want any immigrants who is likely to become a public charge, who is likely to depend on the U.S. public resources to meet their needs. And so this rule is set to curb that and to kind of screen for that, to ensure that you're not getting people who are going to be liabilities to the United States. Is it fair? I'll tell you about that later, but let's talk about the rule. Now, there's a 7-factor test, and every immigrant, is going to have to kind of weigh what they can prove, because the officer has been given a lot of discretion to weigh the 7 factors to determine whether or not the immigrant is likely to become a public charge. What I don't like about this, and I will just give this snippet of opinion, is that these officers now have a wide range. The rule is not like hard and fast. Ignore the phone. The rule is not hard and fast. There's just a lot of discretion on the reviewing officer, and that's why now it's important more than ever that you consider this carefully before you submit any applications, any adjustment applications especially. Now this rule is set. It's going to, as it is right now, it's going to impact mostly adjustment of status applications that are filed in the U.S. However, the FAM code, which dictates the Department of State and Consular Processing, is set, and they've indicated that they're going to copy this rule soon. So it will affect consular processing cases in the near future. Now the 7-factor test is the immigrant's age, the immigrant's health, family status, the immigrant's assets, resources, financial status, the immigrant's education and skills. 6, the immigrant's anticipated period of admission, like how long do you intend to be in the U.S. And lastly, the affidavit of support. Now if you notice, as the way it's listed under the new public charge rule, the affidavit of support, which was the one and only which was the prioritized, I wouldn't say one and only, the prioritized determination of whether or not an immigrant is going to be a public charge. Now, the affidavit of support is all the way in number 7. So the focus is now shifting from the petitioner and the joint sponsor, all, now focused on the immigrant. So if you're trying to bring your parents, or you're trying to adjust your parents who are elderly, who have health issues, who are, have too many children that they care for, this is going to become an issue. All right? Now, as the proposed rule had, they hadn't addressed like housewives or house husbands, but this final rule actually says that unless you can prove that, you're not working because you're taking care of your kids full-time or dependent family member, it's going to be held against you. So you know how the adjustment of status application, halfway through, like at the 4 to 6 month mark, you get a work authorization. By the interview, you better make sure you're working, unless you have a good reason why you're not working, because it's a negative factor for them to see that you're eligible to work and you're not working. All right, so I just want to touch on what kind of factors are going to be negative and what kind of factors are going to be positive. So I just touched on the fact that if you're not a full-time student or you don't have any kind of reason why, excuse why you're not working, you're eligible to work, they're gonna hold it against you. If you're receiving public benefits from certain public programs, like SSI, Medicaid, certain Medicaid, there are few exceptions. That's going to be held against you as a negative factor. If you have a medical diagnosis and you're not able to prove that you have the money or the insurance that to cover those medical expenses, that's going to be a negative factor. And if you have any kind of prior public charge inadmissibility findings from any kind of judge, that's going to be a negative factor. Now, the positive factors that will weigh in your favor is, before, as I said, the income that was important was your petitioner or a joint sponsor's income. And the household income had to be above 125% of the household income based on the chart, the IA-64P chart. Now, the new safe zone is that your petitioner has to meet 250% of the household income. For example, previously, or as it is right now before October 15th, if your petitioner is making if your petitioner doesn't have any children, it's just you and him or you and her, and no other dependents, and they're making, I think it's $23,000, $24,000, you're safe. But with this 250%, you're talking about double that, okay, to be safe. And not only that, the joint sponsor thing is now going to be scrutinized closely, meaning that you cannot have a joint sponsor who is just a friend. You have to have a joint sponsor who is a relative or somebody who has proven over the years to be responsible for your upkeep as an immigrant. So you're now looking at paper trail to show that this person has been responsible for your school fees, responsible for taking care of you, your child care, something to show that there's a trail of sponsorship up until now. And then, the applicant himself or herself should be, if the applicant himself or herself is making over 250% of the household income, then that's also a positive factor. And if you can provide, if the applicant has health insurance, if the applicant speaks fluent English, if the applicant has, certain, degrees or training to show that they have a high income potential in the U.S. These are all positive factors among others. So this video is getting long, so I'm going to cut it short here, but there's a lot to learn about the new public charge rule going into effect October 15th. My advice is, if you are planning to apply for adjustment of status, you should probably do it before October 15th so that you can escape being put under this heavy microscope that is unfair, to say the least. And so do that or hire an attorney to help you, because this is about to be a big deal. All right, I hope that has helped somebody today. My name is Ral Obioha from the Law Office of Ral Obioha. If you like to have someone to consult with or speak with about your adjustment of status application or represent you through the process, you can call my office at 832-569-1110 or visit us at www.ralobiohalaw.com. Thank you and have a blessed week.